Good morning, everyone, and welcome to WorkCover Queensland's Common Law webinar on the importance of maintaining records and keeping detailed file notes when a workplace injury occurs. My name's Tim Loos. I'm a senior lawyer at WorkCover Queensland, and I'm the host today. Before we begin, we would like to acknowledge and pay our respects to the Yuggera and Turrbal peoples as the traditional custodians of the land in which we work and from which we are speaking today. We thank them and their elders, past and present, for their ongoing connection to land, waters, culture, and community. Joining me today is Georgina Wong, our presenter from Colin, and Paisley. We also have Elise in the room to my left, who's running the presentation. She's from our comms team. Some housekeeping. We record the session and we later send a link out to the recording along with the slide pack and a short survey to gather your feedback. The recorded session also gets uploaded to WorkCover's YouTube channel and sent out on socials. All the past webinars are up on the YouTube channel there as well, so you can check those out. You can submit questions during the webinar using a Q&A button at the toolbar at the top of your screen. If you are not logged into Microsoft and can't use Q&A, then please submit questions via the chat function. We do our best at the end to answer as many questions as we get to, time permitting. Some questions came through at the time of registration, which is always good and helpful, and we've incorporated some of those already into the final slide, so we'll address those at the end directly. We're unable to answer any policy or claim specific questions. So if you do have any questions about a claim or your policy, please contact your relationship manager if you have one, or reach out to a customer advisor who's handling your claim for more information. If you have any technical issues, please refer to the help information under the More button, which is in the toolbar at the top of your screen. Now for today's guest presenter, Georgina Wong has more than 17 years experience in insurance and workplace litigation, focusing on public liability, personal injury and workers' compensation claims. She acts for global insurers, WorkCover Queensland, workers' compensation self-insurers, national and Queensland-based companies, local and state governments, and faith-based organisations in personal injury and workplace health and safety disputes. She is a member of the Queensland Accident Compensation Law Society Tort Law Committee and regularly speaks and publishes on current issues in personal injury and workplace disputes. Welcome, Georgina. One final thing from me before I hand over, though, I just always like to add that anything said today by Georgina or WorkCover is just general information and shouldn't be taken as legal advice. And that's all from me. Thank you very much for joining us, Georgina.
Thanks a lot, Tim. Firstly, I'd like to thank WorkCover Queensland for inviting me here today to talk about the importance of record keeping and file notes. Over many years of providing advice in relation to workers' compensation claims, whether it be statutory entitlement or common law claims, I've conducted hundreds of investigations and have had the experience of working with different employers in different industries where some employers have very sophisticated systems in terms of record keeping and file notes. And then we have the other extreme where there really is an absence of that type of system in place. So today we'll talk about some practical examples as to why record keeping and file notes are so important when managing workplace injuries and workplace injury workers' compensation claims. So moving to the first slide. The role of record keeping. Record keeping plays a key role in investigating workers' compensation claims, helping to establish the facts and supporting the decision-making process. The importance of file notes. File notes are an essential part of the injury and claims management process, providing a clear and concise record of events and actions taken. So before we get into some practical discussion about keeping records, making file notes, I think it's important to go back and look at what the law is and why it's so important that we get this right. So if we move on to the next slide. In Queensland, we have a statutory no-fault system. So what that means is if you're a worker and you've suffered an injury which arises out of or in the course of employment where work is a significant contributing factor, you are entitled to workers' compensation, being the payment of weekly wages and also medical treatment. Now, a lot of employers would be familiar with the reasonable management action exclusion under the Workers' Compensation and Rehabilitation Act regarding psychiatric injuries. So if a psychiatric injury has been suffered as a result of reasonable management action taken in a reasonable way, then it is not an injury for the purposes of entitlement to compensation under the Act. And some examples of reasonable management action could be transferring someone to a different role, disciplinary proceedings, and also dismissing the worker. I thought it's important to raise that now because later on when we look at some practical issues regarding record keeping and file notes and managing psychiatric injuries and how reasonable management action can be recorded in that process. So moving on to the next slide. In Queensland, workers also have entitlement to pursue common law claims. So in the annual report for WorkCover Queensland last financial year, there were 3,300 common law claims that were settled. Common law claims, the worker will need to establish that the employer was negligent in order to be awarded a sum of damages. I won't go in terribly too much detail regarding all the legal issues involving common law claims, but in the context of record keeping and file notes, the worker needs to prove the incident, needs to prove breach of duty, causation, damages. And with that top line incident, that is also relevant to statutory claims. That is always the starting point in terms of determining whether someone's entitled to workers' compensation or common law damages. And that is what we will be focusing on today. Moving on to the next slide. So in civil cases, what is the required standard of proof in respect of workers' compensation claims? It's to prove on the balance of probabilities. That means that the claim is more probable than not. So in workers' compensation claims, the injured worker bears the burden of proof in proving the claim, whether that be a statutory claim or whether that be a common law claim. Now, when there's issues where an employer or an insurer disputes a claim, a court or decision maker must decide on the balance of probabilities which party's case is more plausible. Now, this process involves assessing the evidence, which includes weighing the credibility of witnesses, evaluating documentary evidence, and considering expert opinions. So to be, put it in simple terms and to be very basic about the balance of probabilities and proving a case, we need to have compelling evidence. And that's where record keeping and file notes come into play in terms of managing workplace injuries and also workers' compensation claims. So moving on to the next slide. Why does record keeping matter? Accuracy and consistency. It's essential to verify facts to minimise the risk of future disputes. So we really do want to avoid cases where they have to go before the courts for a determination because it's very disruptive, it's very costly. In many cases, disputes arise because recollections can vary over time or change over time. Legal compliance. Now, employers operating businesses would be fully aware that they have legal requirements to keep business records, tax records, employee personnel files. So that's why we need to make sure we keep our records as well. Efficient case management. Detailed records allow the efficient case management by providing a clear timeline of events and actions taken. It helps track the progress of a claim and identifying any delays or issues. The role of file notes. Obviously, documenting conversations. So documenting conversations with employees, medical professionals, other stakeholders. These can be recorded and later referenced. Evidence collection. They can serve as evidence in legal proceedings if there's a dispute. And it can provide a written account of an investigation process and the rationale behind decisions made. Importantly, case management. So with workplace injuries, you may have multiple individuals involved in the process in managing return to work, managing the injury, managing the workers' compensation claim. So it's very important that we have records of what different people have done at different points in time. Moving on to the next slide. What are the best practices for record keeping and file notes? And just very, very briefly, timeliness. It is so important to record information as soon as possible after an event or conversation to ensure accuracy. At the beginning of the presentation, we talked about the balance of probabilities, how to produce compelling evidence to a court so that they decide that your case is more plausible than the other parties. And one of the aspects that the court looks at is contemporaneous evidence. So records, reports, facts recorded close in time to the actual event. Detail. Include all relevant details in your notes, such as dates, times, names of individuals involved, key points discussed, quoting verbatim of the pertinent issues. And we will unwrap that a bit in some practical examples later. Confidentiality is very important these days. Everyone is aware of privacy laws. If there is a workplace injury, someone has a workers' compensation claim, it's important that you're storing that information securely and that only authorised personnel can access that information. So the privacy of the injured worker is protected. So moving on to the next slide. Recording information. Whether it be in your records or in your file notes, it's very important to go back to basics. So who, what, where, when, why, and how. And I'll discuss some practical examples later on as to why that's so important. Also, details. Be factual and be specific. When a workplace injury occurs, it is not a case of less is more. It's more is more. So include as many details as possible so that all the information is captured contemporaneously in the event that there is a future issue that arises in relation to the injury or the claim. So moving on to the next slide. Many employers who are attending today for the webinar would be very familiar with incident reports, and this is an example of an incident report recording details of a workplace injury. And whilst some information contained in this may seem to be very obvious, in my experience in investigating hundreds of claims, it's actually quite surprising. Some details that have been left out at a particular time after an injury has occurred. So I won't go through every single field in this example of an incident report, maybe just some key ones. The description of the incident. As I said in the earlier slides, details, being factual and being specific are absolutely critical when you're recording the description of the incident. Now, for example, if you have a worker who alleges they've suffered an injury by lifting a box of product, it's important not to just simply say, oh, John lifted a box of spanners and suffered a back injury. We need to know the specifics. So you can appreciate the mechanism of lifting a box from the ground as opposed to lifting it from a table or above head height, very different mechanisms of injury. And that information we need to understand in terms of making decisions later on regarding, whether there's a workers' compensation claim, their entitlement, and, later on if there's a common law claim. Again, plant, equipment, product involved. So it's important to capture things like measurements, weights. Again, the box that I was referring to, does it weigh 5 kilograms? Does it weigh 50 kilograms? You can appreciate the difference is significant and a case can really turn on those particular facts. Now, going all the way down to attachments. Over time, I've seen employers get more sophisticated in terms of preparing their incident reports and attaching supporting information. So that could be CCTV, photographs, witness statements. And there's definitely been improvement over time in relation to having all that material available and stored securely, centrally, so that if something happens in the future, that's available to refer back to. Now, just a couple of brief comments before we move on to some examples. If you have photographs, and this is something that I've come across, many times, is that the person taking the photograph may take a series of photographs, say, for example, of defective plant which was involved in an incident, which the person taking the photograph, it's very obvious as to what that all means to them because they've got that first-hand knowledge. But someone picking it up, whether it be 6 months or 2 years later, may not be as obvious to them. So in circumstances like that, it's great to put a little description with each photograph, say, was the defect on the right side of the cabin? Was it on the left side, or the rear, or the front, or the ceiling? Those types of particulars, just so that when we look at it at some time down the track, it just makes it a bit more clearer. Because in cases I've been involved in, plant gets disposed of, it gets sold on, it's moved to a different owner, it may change, those types of things. So it's good to capture that information at that time. So I might move on to the next slide. Now, I've already referred to some of these aspects. The first one, name and position titles of person involved. So in an incident report, I've seen many occasions the name of, different people have been stated in there. They're involved, whether it be the person that the incident was reported to or witnessed, those types of things. It's really valuable to state what their position is. Were they the workplace health and safety officer? Were they the production supervisor? Were they, a truck driver? Or were they an employee of a subcontractor? Over time, people move on, they change roles, they change positions. It's really good to have that information in the incident report to give context as to, the roles of the people that were involved in the incident. Dates and times, of course, very important. I've referred to CCTV and photographs. Just briefly on CCTV, great if you have CCTV capturing the actual incident, but we also need to ask, okay, do we need to look at things as to the potential or the possible cause of why the person suffered injury? And an obvious example is, say, a slip and fall on the workplace. If someone slipped on some substance on the floor, great, you've got captured the actual incident in itself, but we really need to know and look back as to how it actually got there in the first place. So if you can, draw your mind to those types of questions and, capture that CCTV footage and record it with the incident report. Plant, equipment, product specifications, I've already referred to that in the earlier slide. Okay, moving on to the next slide. Just very briefly, I will go through some documents and records which will be relevant and assisting in managing workplace injuries and claims. So staff rosters, very important to keep records of your staff rosters, times, including breaks. Say, for example, if you have over a period of time injuries where there's claims of, no rotation or inadequate rest breaks, that's something that we need to go back and have a look at. Well, what it actually did happen around that time. Access code records, so digital card access is becoming very common these days in the workplace. Also, very good to understand where a particular person was at a particular point in time. Workstation and area. So if you can keep records as to which area of the production the person was working in at a particular point in time on a particular day, that can be very helpful in narrowing down any potential issues that may arise in the future. Training. Now, the issue of training documents, that's really relevant to when we look at common law claims. So whether the employer provided adequate training to discharge its duty of care on that particular aspect. So in a lot of claims where I've requested training documents or training records from employers, they will come back to me and give me a training history. So it might be a spreadsheet, it might be a one-page document with a list of training the person's undergone at various dates. And you can see they've undergone manual handling training maybe every year since they've been there for the last 15 years, which is wonderful. But that's only part of the story. We need to have a look at the training content. So it's important to make sure you're keeping records of your actual training content and the versions of it provided over time, because it's the version that was in place immediately prior to the incident which is likely to be the most relevant in when we look at those issues of adequate training in common law claims. Attendance and sign-off sheets, competency assessments are absolutely critical. You can have the best training ever documented, but unless we are able to prove that the person did receive that, understood it, then again, there's likely to be complications in proving that the employer provided adequate training. Lastly, the name of the trainer. Again, very important if there's something that needs to be clarified. And it comes up very often that we will need to track down the trainer and find out exactly how it was delivered, how competency was assessed. Just moving on to the next slide. So policies and procedures, I guess this is very similar to, training. You need to make sure that you're keeping versions of that stored in your records, because different versions will be relevant at different points of time, depending on when the injury was suffered. Also clearly noting review dates of when the policies or procedures have been changed, and again, authors and reviewers, because we may need to contact them to ask them questions about certain things. Contracts are also very important to make sure that you're keeping as part of your records and storing them. I've lost count of how many cases I've been involved in where we ask for a contract to understand, say, for example, if there's a subcontractor involved in a particular case, and we receive the contract, it's either not signed by either party, or secondly, it's signed by one party. So you need to be keeping your fully executed contracts. Where it's not signed or partially signed, it doesn't necessarily mean that we won't be able to prove that the parties agreed to the contract. There's just probably a few more hoops that we would need to jump through to do that. But if you do have a fully executed copy stored on your records, then hopefully that will minimise any issues or dispute in the future going forward. Audio and video recording. So this was a question that one of the webinar attendees had submitted at registration as very contentious. So I'm going to put a very big caveat on this, that it's can be determined on the facts of each case. It's also the legal position is also different across different states in Australia. But in Queensland, we have the Invasion of Privacy Act, which states that in terms of recording a private conversation with someone, at work, whether it be the employer and the employee, if you're a party to that private conversation, that's lawful. You can do that. Where it gets complicated is if you decide to use that recording for a particular purpose. Generally, you need consent from the other party to the private conversation in order to do that. There are some exceptions in respect of whether they were made for legal proceedings or used to protect particular interests, which is probably a whole webinar in itself. But generally, the answer is yes, you can, but it's an offence to use them if you do not have consent from the other party. Following on from that, where covert recordings have happened in the workplace, the Fair Work Commission has been very critical of that, regardless of whether the legality in the particular state in which the recording was obtained. And that's because it breaks down the trust relationship between the employer and employee. So just something to bear in mind for both workers and employers regarding recording conversations. Lastly, the Telecommunications Interception and Access Act is federal legislation which deals with recording telephone conversations of your employees. But generally, no, you cannot do it without consent. So just something to bear in mind for employers. Okay, moving on to the next slide. Some other obvious items that we need to make sure that we're recording: medical certificates, medical reports. Very important in matters where someone's gone off work for quite a long time for a non-work related matter. So, they may have injured their back when they went on a ski trip, and they've given medical certificates or, correspondence from their doctor regarding that. They eventually get back to work and they're working in the workplace for a while, and then they suffer a back injury at work. So we need to have a look at that evidence to, make a decision whether in fact the injury is a work injury or something relating to the person's pre-existing condition. Suitable duties and return to work plans I'll get into a bit later in the presentation. Some other obvious things: payroll and leave. Payroll, not just to calculate the person's weekly entitlements they're on compensation, but also if there's a common law claim, to calculate what the person's potential economic loss is. Digital storage, very important to have records kept in a centralised area where authorised personnel, the business understands where they're kept and where they can be referenced, when required. I had a matter where the workplace health and safety officer had left the business, and it was probably 2 or 3 years later that someone at the business was going through the person's old hard drive and then had found all these investigation reports, all these incident reports that had been missing for a very long time. So obviously a very difficult position to be in, but also setting guidelines in relation to storage or record keeping, to have it centralised, to understand where it's supposed to be kept, having those guidelines of not storing it on individuals' hard drives, just to make sure that when you do need them, they are available to you. Just moving on to the next slide. So file notes. File notes are absolutely critical, especially when managing claims over time, return to work. If say you have instances of the psychological injuries, whether it's arising out of performance management, a chronology, communication log is absolutely invaluable. So ensure that dates, names of persons who's making the file note are recorded and included in the information. And that may seem very obvious, but I have again lost count the number of times I've come across file notes where someone has handwritten something, but there's no name, there's no date. So proving that is going to be very difficult. And also, say, for example, the date issue, as I have mentioned earlier in the webinar, the contemporaneous evidence is absolutely critical in trying to produce that compelling evidence to avoid future issues in dispute or to resolve them when they come up. Details, again, be factual and specific, and as I've just mentioned, timeliness, absolutely critical. So moving on to the next slide. Mental injuries. So we're going to go through some practical examples as to how record keeping and file notes can assist with managing certain workplace injuries and claims. Now, a lot of employers are aware that mental injuries or primary mental injuries and even secondary mental injuries are on the rise nationally. So in WorkCover's last annual report, there were 3,364 workers' compensation claims, which made up around 14% of the total statutory claim costs. So, definitely on the rise, definitely costing the scheme more in terms of compensation managing those claims. So how can accurate record keeping and file notes assist? There's a couple of examples I've included in there, and given we've got time limits, when we have this common scenario of an over period of time workplace bullying and harassment claim with multiple stressors, and what's very topical at the moment is work from home. So a lot of employers are requesting their employees to come back into the office. They may have been working from home full time since the coronavirus pandemic, but now employers want them to come back into the office. And I've seen cases where when those requests have been made, the worker may not want to come back in, and then that's the start of a number of other stressors being reported by the worker, which then eventually leads to a psychiatric injury and then a workers' compensation claim. So in that circumstance, it's incredibly important to make sure that you are keeping accurate records. Say in that example, the communications are delivered to your workforce regarding, working from home, return to the office. And if particular individuals have raised concerns, then to make sure you are having detailed file notes of those conversations and having them recorded as verbatim as possible. So that later on, if there's an issue that arises, you can draw from that. Hopefully the records and file notes will be accurate, they'll be consistent, and if there's a claim made, we need to have a look at well, was the injury the result of reasonable management action, being the request to for the person to come back into the office after work from home arrangements. There's a couple of cases that I've put in that example which deal with over a period of time, primary psychiatric injuries, alleged bullying and harassment. So it's important to record those conversations, which will later be relevant is in terms of decisions regarding what exactly happened, the facts, and then going on to determine whether it was reasonable management action for the purposes of a workers' compensation claim, or if it's a common law claim, where there was a breach of duty based on the employer's conduct. Now, the next example is primary mental injuries arising from critical or discrete incidents, and I'm just conscious of time. So there are a couple of cases there. I believe the first one, Poles, is an assault case, and the second one is Walters is a verbal assault from a supervisor against a worker. Again, contemporaneous records, whether it be recorded in an incident report, witness statements, file notes, very important to capture that information immediately after those critical incidents occur, so that if there's some disputes regarding what happened, those can be readily resolved at that point in time. Now, moving on to the next slide, physical injuries. I've just listed the different types of physical injuries there. So we've got manual handling, slips and trips, falls from heights, plant and objects, occupational exposure. I will probably focus on the first example, given I've mentioned slip and falls before. So over a period of time, repetitive lifting, those two cases that I've given under that example, it actually comes up quite often where someone says that they've suffered, whether it be a back injury or a shoulder injury from repetitive lifting over a period of time, where there were no rotation of duties, no rest breaks, things like that. So, staff rosters, records regarding which area the person worked in at the relevant time, what products they were handling. So obviously someone lifting, 5 kilogram boxes of screws is going to be a lot different to, cartons of soft drink, during the course of a whole working day, extrapolated out, over a couple of months. So very important to keep those records as to what exactly is the work the person is doing, over that period. Slip and falls I won't go into because I mentioned it earlier. I'm just a bit conscious of time. And we just might move to the next slide. Third parties, I've already touched on contracts previously. Having those fully executed documents are very important, so that, if there's issues regarding the roles and responsibility of parties, the sharing of culpability for a workplace injury, we can draw on that contract and understand, okay, well, what is the likely contribution between two or multiple parties. If you're a labour hire employer, if you undertake site inspections at a host premises, very important to make sure that you're keeping records of the dates of when those occurred and exactly what was inspected, because it can assist you in demonstrating, what reasonable steps you took to make sure your labour hire employee didn't suffer an injury at the host employer's premises. So moving on to the next slide. Return to work and suitable duties. So I think we're heading towards the end now. Having return to work plans, suitable duties are incredibly important in managing a worker's return to work. So they need to be, stored. They need to be discussed with supervisors and the parties to understand exactly what the person's restrictions are when they return to work, and their rotation, rest breaks, and how they're going to be supervised. There's been many cases I've been involved in where the person goes back to work on suitable duties, they've got a 5 kilogram lifting restriction, and for whatever reason they're allocated to lift a 20 kilogram gas bottle at the workplace. So very important that we keep records of exactly what their suitable duties are to make sure that they're complying with them, and obviously to prevent another injury occurring in the workplace. So moving to the next slide. So we're at the end now. There might be some questions at the end, or there are some questions, but just to wrap up. So accurate record keeping and detailed file notes can assist with preventing and minimising issues in dispute, expediting the claim decision-making process. And it can also preserve the relationship between the employer and employee. It achieves early return to work outcomes, also assists with risk management and the early resolution of statutory and common law claims. And that last aspect is probably the really important aspect, because it's generally accepted the longer a claim goes on, whether it be statutory or common law claim, the more expensive it becomes, the more costly it becomes. And for employers operating a business, it can be very disruptive. For injured workers, it can be very stressful, causing a lot of anxiety. And if things aren't recorded contemporaneously so that they can be referred to at a later stage, and there's a disagreement between the employer and employee, it can create animosity and a breakdown in the relationship. And we know from looking at past cases that that increases the likelihood of a worker making a common law claim. So it's important that we have accurate record keeping and detailed file notes, so that that information and facts can be recorded at that time to prevent those future disputes. So we might just move on to the some questions.
Is it possible, Georgina, I wasn't clear that you have the full hour. We've got the full hour to talk up until 11 o'clock. So hopefully you weren't rushed there or feeling rushed, but we'll get through the questions. We've got another 20 minutes, and some have come in while you were talking as well, but we'll run through the ones up on the screen. So the first one up there is, should daily notes or subject notes be outlined as verbatim as possible, or can evidence be collated as notes pertaining to a phone call?
Yes, that's a very interesting question, and I don't think it's probably practical to try and record everything verbatim in a file note, but as closely to the conversation as possible. Say, for example, I have some cases where if a party makes a statement about something very particular, very peculiar, when I'm doing up a file note, I will actually quote them, that what exactly they said to me at that particular point in time, so that if there's an issue later on, that can be referenced back. But file notes need to be as accurate and close to the conversation as possible. Now, if there's an issue in dispute, the author of the file note is going to be asked about, okay, well, how did this conversation take place? Did it take place immediately after the incident or the event? How did you record your notes? Some people might say, oh, I record exactly what the person told me, or and as we've discussed earlier in the webinar, having those contemporaneous notes are absolutely invaluable. It is more compelling. And I guess if you want to look at it from a common sense perspective, something that you record on the same day is going to be more accurate than 6 months later. And giving an example, if a matter went to court before a judge, and if you recorded a note 6 months later, you would be cross-examined on that as to, well, between the date of the incident in January and in July, what did you do during that period at work? What did you do in that period in your personal life? Da 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 da. So, are you confident that what you recorded 6 months later is accurate as to what happened on the day? And common sense would say that it's not going to be as accurate as if you had recorded immediately after the event or the conversation.
Thank you. Good answer. The second one up there is about recording a conversation. Can it be done? Which you touched on very well before. I think you covered it all, but I suppose I could add, from our perspective, we sometimes get calls from employers and from claimants themselves saying, I've got this recording I did. Can I send it to you? And we're always very careful that as Georgina said, that whilst the Act might allow recording of a conversation if you're a party to it, what you then do with it might then be an offence. And we WorkCover are very careful about telling people what they can and can't do under offence provisions under other acts. So just always be super careful with that stuff. And is there anything you wanted to add to that?
No, that's a very good point, Tim. And as I said earlier, it's a very complex situation to be in, and they are dealt with on a case-by-case, basis. But as I said, general principles, you will need consent from the other party or parties participating in the private conversation.
All right. Number 3, can you discuss the injury recording issues associated with psychological injuries related to performance management?
Yeah.
I think you touched a bit on that sort of.
Yes,
injury.
this is a very interesting question, and when I was thinking about this, with performance management, it is a complex process. It's a very sensitive process as well. And the starting point with performance management is to make sure that you have a good framework. So you have a good framework as to your policies and procedures as to performance management. When someone goes on performance management, what that actually looks like in terms of recording information, say, for example, what they're not actually, meeting in terms of the requirements of their role, what measures that they need to, or what goals they need to achieve, timeframes, those types of things. Now, the injury recording issues that I've seen coming out of this process is, someone goes on performance management, they have a performance improvement plan, there's things outlined in that, what they need to do to bring their performance up. But then later on, there's something else that's introduced. There's something new that's introduced to that that's not actually in the plan. So that's inconsistent with, the process. And in that particular case, when we're looking at things like reasonable management action taken in a reasonable way, that wasn't reasonable because the person wasn't put on notice that this new thing that was brought up by the employer, they weren't meeting. They weren't meeting, and they weren't meeting their inherent requirements of their role, their performance for their role. So what I can emphasise is, make sure the framework is right at the very beginning, and then what flows from that, where you, whether it's giving like notices of meetings with the individual when the meeting occurs, recording the conversations that take place, and then your action items that follow afterwards. If you have a framework, any potential issues should be, avoided or prevented, so long as you follow that framework, those guidelines, for that very complex process. And of course, what's very important in that process is that your staff are adequately trained in how to undertake performance management.
I think that was a good answer, and I'm going to just repeat essentially what you just said, but we see in stat claims a lot the question of, was it RMA done reasonably, and often the first port call is, what does your policy say and have you followed it, and it can sometimes be as simple as that. If there's a good policy in place for doing these things and they can demonstrate, or employers can demonstrate that they've followed it step by step, then that's a pretty good indication that it's reasonable management action done reasonably.
Yes, definitely. Yes.
Next one is about how notes are recorded and saved. So the question there is if they're written into a Word document or saved as a PDF. I suppose that this could even include if you have software where you type in notes as well. Is that as good as handwritten notes to prove that the recording was done at the time, I suppose?
This is a bit of a tricky question because we're in the day and age where everything's digitised, everything we do electronically, and handwritten notes are really the exception these days. I think, say, if we had a matter before the courts, a handwritten file note is very compelling because it's very personal to the author who's creating it. But electronic file notes can be, very valuable as well. Now, regardless of whether they're handwritten or electronic, they're going to have to be proved if there's an issue before the courts, which is by calling the author a witness who created the document. So yes, file notes can be taken as a Word document and saved as PDF and later used for evidence, whether it be at the workers' compensation stage or the common law stage. There may be things done in addition to that to verify the content, whether that by namely speaking to the author or the witness involved. But electronic file notes are still very helpful in being used as evidence in for claims.
The question 5 there is, what's the best way to record that an employee is performing their work role at the pre-injury standard when they're returning to work?
This is a bit of an interesting question, and I wish the person asking it was available to elaborate a bit. When someone returns to work, and I'm assuming from this question that they're doing their pre-injury role, I guess the starting point is they would have received a medical clearance, or you'd hope they had received a medical clearance that they're capable of performing their pre-injury duties. So when they get back into the workforce, they do have their inherent requirements of their role. And I think when employees go back to work, the employer simply needs to rely on the fact, well, they've been cleared. Like, unless they've received any other information to the contrary, there's a reasonable expectation that they will, perform their normal duties. And then recording, like, whether their work is at the pre-injury standard, I guess that can follow in the ordinary process of, supervising them. Now, are they meeting their daily quotas, their daily KPIs? Whether they're participating in, team projects, all those types of things. So I think, in the context of the person receiving a medical clearance, it's really to see and supervise like what they're actually doing after they return to work. I think that's probably the only reasonable thing that an employer can do in the context where the person's received a medical clearance to return to work.
I sort of took that as like it's an issue that goes to, I suppose, future economic loss at the damages stage, isn't it? That's how I read it as.
Oh, okay. Well, there's some other things that you can look at as well. Like, say, for example, are they working their full hours? Are they taking any time off work? Are they working overtime? So those are some other things that you can look at as well. Like if they're, previously they, worked a lot of overtime before the injury, and then, when they return back to work, they've given that all up, maybe because they can't cope or whatever. That's maybe an indicator as to, well, are they, coping with their role? But again, it needs to be looked at on a case-by-case basis, because in a lot of workplaces, overtime is optional. So they may be, make a personal decision they don't want to do that anymore for family reasons or whatever.
The only other thought there was talking to the worker themselves and checking how they're going. If they've just come back to work from an injury, presumably you're supporting them with their rehabilitation, and then this question assumes they're back to their normal role, but still no harm in checking in with them as you would any employer.
Yes, absolutely. Yeah, absolutely. That's a very good point.
The last one up there, what are the implications if previously our record keeping wasn't great?
This is there's a lot of things that come out of this question. So I guess the webinar is focused on the importance of record keeping file notes to prevent future disputes. So the implications, if it's a case of there being no documentary or contemporaneous evidence recorded in some type of document form or a file note, and if you have situations where it's one party's recollection differs from the others, then obviously there's a dispute there. It's going to take some time to resolve. And what that translates to in the context of managing the workplace injury, workers' compensation claims, there can be animosity that develops between the employer-employee, a breakdown in the relationship. There may be delays in respect of making a decision on a statutory claim. There may be delays in investigating a common law claim and achieving a resolution that may have been earlier achieved if there were documented evidence of the actual incident or issue that the parties are disputing about, which then causes, additional costs and business interruption to employers. But over my time in investigating a lot of these claims, we all wish we had a crystal ball. We all, hindsight is wonderful, but through going through processes where your record keeping wasn't, necessarily ideal or assisting you in a particular case, it's a really, really good opportunity to learn from that. It's like, okay, well, we missed these things out or miss out on these things on this particular occasion. Let's improve our systems. Let's improve our processes. Let's train our people to make sure that our record keeping is improved and our file notes are recorded, up to a really good standard, so that, touch wood, if something happens in the future, that those resources are available to assist with preventing a similar dispute from occurring again.
Thank you. We've had a few more come in while you were talking, and there are 3 that Elise has passed over to me. Happy to
Sure.
on the spot.
Sure.
So the first one here is, what evidence would you expect to see to confirm a worker has understood their training? Is a signature on attendance at training sufficient?
That is probably not an easy question to answer, because even if they've signed off on a competency sheet or an attendance sheet, there can be disputes, and it does come up quite often. And I've been involved in claims where, say, the worker says, "Oh, I attended the training, but it was just really a series of PowerPoint slides. No one really explained it to me. I just signed the sheet and then went off on my merry way." But then you will have an employer saying, "Oh, no, there was this particular trainer employed in the business. They give a presentation on the training, on the PowerPoint slides. They ask questions of the individuals and, assess their competency accordingly." So there's no simple answer to that. So just because you have an employee sign off on an attendance sheet, a competency assessment, it may not necessarily be enough, but it is a lot better than you having, not gone through that process. It's still may be challenged as to whether they fully understood and comprehended, which may need to be resolved at a later stage through other pieces of evidence, say, the trainer. I mentioned the trainer before, but it's better than not having, anything at all. It just makes your task a lot more difficult in proving that adequate training issue for purposes of defending a common law claim.
Thank you. 2 of 3 here. Are there any specific requirements when recording witness statements? You've touched on sort of what content should be included. So maybe if we take this as more a formatting, what should the introductory paragraph say, and should it be on a particular form, and what does the signature block need, that sort of thing, if we take it that way, perhaps?
Yeah. Well, this probably could unpack in a whole new webinar. I'm actually giving this type of training to my internal team very, very shortly. So the individual needs to be identified. So who the witness actually providing the statement, and if you want to, put it in an ideal statement, you need to identify the individual, so their full name, date of birth, their address, so that, say, the John Robert Smith is the John Robert Smith that you spoke to and who gave the statement. So they need to be clearly identified. And then, whatever their content of the statement is, and their signing clause, to have a witness that has, witnessed their signature on the signing clause. You can put a little paragraph in there regarding they've acknowledged they've provided the information which is true and accurate and correct and pursuant to the Oath Act, I don't think it's absolutely necessary when you're obtaining a statement as an employer, because later on they, are going to be put to proof in relation to that if there's a contest as to the content in the statement. But one of the fundamentals is they need to be identified. We need to know, this is the John Robert Smith that's given the statement, and not someone, you know, living in Tassie somewhere. I hope that.
I think so.
Is,
yeah. Thank you. And the final question we have is about personal information. How do you ensure personal information of staff is kept confidential while complying with record keeping? It says regulations, but obligations, I suppose, will take it as.
Yep. Okay. So again, it's really the case of, like, in a workplace injury. So it is a very sensitive issue in terms of, you know, personal information, medical information relating to the person. So you will have, like, say, for example, your dedicated HR team who will have restricted access to all those documents and records in managing the person's, you know, injury, return to work, workers' compensation claim. So by having guidelines, systems in place, or information barriers to make sure that only those that have authorised personnel have access to that information. Training is also, you know, very important to make sure that the information is not inadvertently released to, you know, third parties or other people internally in the business. But you need to have, you know, a set of guidelines as to who has access to what types of information in your business.
Thank you very much. And that was all the questions we had. And you've timed it out perfectly, so thank you very much. We're just about at the hour. So that's all the time and all the questions we have. If there were some more questions that you sent through and we didn't get to them, I'm sorry. Thank you very much to Georgina for presenting today. As we said at the start, we've recorded this session and we'll send it out to everyone by email. It'll also go up on YouTube and there'll be links on social media. As I said at the start, the YouTube channel, WorkCover's YouTube channel, has all our previous ones and there's lots of interesting ones there. We'll try and do one more before Christmas, one more of these common law webinars. I'm not sure if we'll get there, but we'll try. And just a reminder, roughly this time, or roughly Christmas time last year, we did one about social functions, including Christmas parties. So check that out, I suppose, as we're coming into November, December. If you're interested in future ones, keep an eye out on your email, LinkedIn, and the events page of the WorkSafe Queensland website. That's it. Thank you very much for attending today. We appreciate it.
No, thank you.
Thank you, Georgina.